I'm Elizabeth Felty, and I want to welcome you to our lecture this evening by Dr. Susan Haack, and it's entitled Religion, Evolution, and the U.S. Constitution. I also want to thank Troy University Dothan for providing the venue, and quickly remind everybody, no eating and drinking, and please turn off your cell phones. There are restrooms located in the hall over there. This lecture is sponsored by the Southeast Alabama Freethought Association, known as SEPA, and we are a local nonprofit organization made up of rationalists and freethinkers. Our primary focus is to provide educational opportunities regarding the constitutional principle of the separation of church and state, as well as the theory of evolution through natural selection. SEPA works to promote secularism and free thought, and in the process provides opportunities for socializing, networking, and friendship. We have regular social events, educational meetings, and we also perform community service, including an adopt-a-mile trash pickup and donations to local secular charities. For more information about SEPA, you can go to thesepa.org or search for the Southeast Alabama Freethought Association on meetup.com and on Facebook. We would also like to invite you to join us every Sunday at noon at Dakota Coffee by Flowers Hospital. The format this evening will be the lecture by Dr. Haack first, and after the lecture we'll have a question and answer session followed by a book signing at the table where we have books for sale. Now it is my honor to introduce Dr. Susan Haack, a distinguished professor in the humanities, Cooper Senior Scholar in Arts and Sciences, Professor of Philosophy, and Professor of Law at the University of Miami. Her work covers a wide range from philosophy of logic and language, metaphysics, philosophy of science, pragmatism, both philosophical and legal, and the law of evidence, especially scientific evidence, to social philosophy, feminism, and philosophy of literature. Dr. Haack has written numerous books and articles, including her latest, titled Evidence Matters, Science, Proof, and Truth in the Law, which will be released this summer. Professor Haack has won an award from the American Philosophical Association and another from the University of Miami for excellence in teaching, and also from the University of Miami an award for Outstanding Graduate Mentor, the Provost Award for Excellence in Research, and the Faculty Senate Distinguished Scholar Award, as well as the National Forecrush Award for the Excellence in Writing. She was included in Peter J. King's 100 Philosophers, the life and work of the world's greatest thinkers. So please join me in welcoming Dr. Susan Haack.
Good evening. Thank you. First I have to switch myself. Is it working now? Yes. It's working now. Okay. I hope you weren't expecting a sermon. This isn't a sermon. It's more like a history lesson. And I'm sort of mostly wearing my law professor's hat, but not entirely, as you can see. Oh, I kind of like that. I thought you might too. Well, you might also like, I like this one too. But this one's serious, because it reminds me of a creature, the fossil of which was discovered 10 years ago by a team which had been going to the north of Canada every year for 5 years, digging, looking for something like this. It found it, finally, in the last year of the grant. A very ugly fossil of what must have been a very ugly fish, with a face like a crocodile, and the usual fins. But when you look at the bone structure inside the fins, my God, it's like leg bones. That's the transitional creature between fish and reptiles. They finally found it in 2004. This creature will play a small role in my story. That's not him. He's much better looking than the picture. Highly relevant to my subject today because that's the evolution of the establishment clause of the US Constitution, and specifically the role it's played in cases over the teaching of the theory of evolution in public high school. Okay, so How did it all begin? Well, I think it would be safe to say it begins in a way in 1785, before the ratification of the First Amendment. Why? Well, because when Virginia was just a colony, it had an established church. The Anglican Church was the government church of Virginia. And in 1785, after a lot of noise from people who were very upset about having to pay taxes, out of which Anglican priests would be paid, when they weren't Anglicans, Jefferson drew up a bill to disestablish the Anglican Church in Virginia, and James Madison introduced it, and it passed. The very same people are responsible for the First Amendment to the US Constitution, which was introduced by Madison and ratified in 1791. Much of it's about freedom of speech, of course, of enormous importance, but I'm putting that aside. The relevant parts for this evening's lecture are: Congress shall make no law respecting the establishment of religion. That's the Establishment Clause. That's all there is, 10 words. Or prohibiting the free exercise thereof. That's the Free Exercise Clause. I recently read an article in the Bar Journal with the title 10 Tortured Words, which is about the history of trying to interpret this so that it's appropriate to the circumstances of the day. I think it's reasonably clear that in the beginning, Madison's understanding of this clause was simply, there shall be no established national church. Nothing like the Church of England in England. It was only about an established church. It was only about the national government. That's a very modest understanding of this clause. But when he was president, Jefferson introduced this very famous metaphor of a wall of separation between church and state. That was his understanding of the Establishment Clause. It's much more ambitious than Madison's was. It's not original to Jefferson. The idea comes from a man I much admire, though he was a religious person, Roger Williams, founder of the state of Rhode Island. A refugee from theocratic Massachusetts, which had been persecuting him for his religious beliefs. It was he who had the original idea of a separation of church and state. It's an idea which has flourished in this country. I think it's very important. His thought, though, was, I don't want the government interfering with the church. Not, I don't want the church interfering with the government. Still, an admirable idea, and an idea we wouldn't have but for him and but for Rhode Island. When Massachusetts was a theocracy, Rhode Island had no religious persecution whatsoever. When Virginia had an established church, Rhode Island was this beacon of separation. Here's how I see it. On Madison's understanding, there is really no tension between the two religion clauses. They sit side by side, quite comfortably. And it seems perfectly adequate for the very young United States, which was a more or less uniformly Christian nation. I mean, almost everybody was Christian. They weren't all the same sect. That was why Williams was persecuted in Massachusetts. But they were nearly all Christian. Jefferson's seemed a lot more sustainable in a nation of radical religious diversity, which is what this country now is. As far as I can tell, the two understandings have been fighting each other since the very beginning. For a very long time, Madison's idea is predominant. And the Jeffersonian idea takes over. I think I can date it. 1947, the Jeffersonian idea becomes predominant. It's been predominant ever since. Though Justice Scalia has never bought it. Of course, when the First Amendment was ratified, There was no theory of evolution. Darwin was what, a twinkle in his grandfather's eye. And there were no public schools. So the issues which have been most contested recently couldn't possibly arise. World changed. 1859 publication of The Origin of Species, 1871 publication of Darwin's The Descent of Man, defying the theory of human beings, which he didn't in The Origin of Species. I'm pretty sure you know this. One of them is the marvelous passages in The Origin of Species. You have all read it. No? You should all read it. It's great stuff, and moreover, it's the last scientific classic a layperson can read. Science got very specialized, very technical. It's not possible anymore. You can't go read the latest advances in physics and understand it if you're not a physicist. But The Origin of Species, you can read. You probably know Darwin argued very, very cleverly against William Paley's watchmaker version of the design argument for the existence of God, and offers a cogent account of how the eye might have evolved, for example. That was Paley's favourite. And I'm sure you know his work caused a storm of religious protest, just a storm. Pope Pius IX was banging in Electron, the Bishop of Oxford was banging in Electron. William Whewell, who was no mean philosopher of science, he was actually a very clever guy, also president of Trinity College, Cambridge, refused to allow Darwin's book in his college library. Not on my watch. The literal reading of the book of Genesis, or either story in the book of Genesis, because they're two different stories. And moreover, it really does undermine the design argument, just as Darwin. Did you know Darwin started life as a theology student? He wasn't a very good student at school. He'd much prefer, he was very slow going to school because he saw interesting bugs on the way, so he'd always show up late with pockets full of bugs. And he obviously wasn't going to go into the army, he wasn't that kind of a guy. Well, we'll put him in the church. So he was a theology student for a while. That was why he knew so much about William Paley. He'd been taught from Paley. But the theory of evolution is formally compatible with the creator God working through evolution, which is a view that we will encounter in due course tonight. Though I think it's clearly in tension with the idea of human beings as created in God's image, as the chosen creatures. After World War I, public high schools were in place. And in those public high schools, there were biology textbooks, and in the biology textbooks, there was material on evolution. I've looked at some of them. I don't actually feel entirely comfortable with them. There's evolutionary stuff, okay, good. There's also eugenics stuff, which is kind of off-putting, but we'll talk about that if you want. At the same time, though, fundamentalism and big digital literalism were on the rise, and so was unease about those textbooks. Parents were seeing what their kids were bringing home and saying, oh my goodness, this is irreligious. And there were laws passed banning the teaching of evolution. Oklahoma was the first, Florida was next, Tennessee next. That was the famous Butler Act. I'm sure you know about Scopes' monkey trunk. You know about the Scopes. John Scopes was not the biology teacher, he was actually the mathematics teacher who had taken a biology review class for a colleague who was away. And he volunteered to serve as a defendant, helped by the ACLU, to challenge the Butler Act. The idea was to challenge this act under the establishment clause, get it deemed unconstitutional, put an end to this, banning the teaching of evolution. Until the O.J. Simpson trial, this was called the trial of the century. no wonder, wow, the people involved are really something. William Jennings Bryan, several times presidential candidate for the Progressive Party, one of the architects of prohibition, for the prosecution, and Clarence Darrow, the most famous defense attorney of his day, for the defense. The movie is great, the play is great, but it's not actually very reliable about the real story. My husband always says it's a good job Spencer Tracy's dead or I don't have to worry about it. I like him so much. In fact, here's the story about what really happened. Stokes was duly convicted, which everybody intended should happen. He was supposed to be convicted. He was fined $100. The ACLU thought, yay, now we can take this to the US Supreme Court and get the thing deemed no. The Tennessee Supreme Court overturned this ruling on a technicality. What technicality? The judge set the fine. That was wrong. The jury should have decided what the fine was. So the Tennessee Supreme Court overturned this, and there was no opportunity to take the case to the US Supreme Court. History would have been different had it not been for that technicality. After the trial, legislatures were not quite so keen on anti-evolution theory, so far so good. But two succeeded, one in Mississippi, one in Arkansas. And at the same time, textbook publishers, who were in the business of selling books, after all, cut down the evolutionary content of the biology book. So there was a sort of truce, because the legislatures weren't pushing so hard, but on the other hand, the textbook publishers were backing off of it. If whole states won't use your textbook, it's bad business. So, water down the biology. Then 1947. Finally in 1947. For the first time ever, the Establishment Clause is applied to the states, what a state does and not just what the federal government does. It was interpreted as requiring government neutrality between one religion and another. Madison and Jefferson found nothing strange about that. And also between religion and non-religion. That's a very modern idea. And the first time you see it in the line of cases is 1947. At the same time, you see another big shift from a Madisonian to a Jeffersonian understanding. And this is very striking because it's not just in the ruling, it's in the dissent. Everybody agrees we're talking wall of separation now, even though they disagree about whether the action of the state in this instance is or isn't contrary. Did I miss a few? Excuse me while I go back. I have an uneasy feeling that something went wrong. Okay. Something went wrong. I missed a slide. I don't mean I didn't show it to you. I mean, it's not there. I should have told you about Epperson. Epperson versus Arkansas. Really interesting case. Susan Epperson was a school teacher in Arkansas. Susan Epperson, teacher in Arkansas, which has an anti-evolution bill. So on the one hand, she is constrained by state law not to teach evolution. On the other hand, the state of Arkansas provides biology textbooks for these classes, and they've got evolution in. So what's she supposed to do? Well, what she did was sue, and that got the Mississippi law struck down. All right. Sorry about that. In the early 1960s, we get a ruling in Kent which explains neutrality as requiring that government action has neither the purpose nor the effect of either advancing or inhibiting religion. 10 words, getting much more complicated. In the same period, Sputnik, right? The Russians get Sputnik into space, and people start worrying, oh my God, we're losing the space race. We're losing the space race. Russians are winning. Around the same time, the National Science Foundation is founded, and that means that there's more federal money for scientific research. And the National Science Foundation soon set up a biological sciences curriculum committee, and that curriculum committee put out new, serious evolutionary textbooks, no watering down anymore. So you see, we're getting ready for another explosion. Decisive test of anti-evolution. There it is, Emerson. Supreme Court struck down the Arkansas anti-evolution act, not the Arkansas Supreme Court. And in 1969, the Mississippi Supreme Court struck down the last remaining anti-evolution act. So you can no longer forbid the teaching of evolution. Okay. Not over. Not over today. It's still certainly not over in 1971. In 1971, the US Supreme Court comes up with the Lemon test under the establishment law. What does a piece of legislation have to do? It must have a secular purpose. It can have a religious purpose, but it must have a secular purpose as well. Its primary effect must be neither to advance nor to inhibit religion, and it must not foster excessive entanglement of government with religion. These 10 words are exploding, you may have noticed. At the same time, though, the idea of equal time is on the rise. There's actually an Equal Time Act about equal time for political advertisements from both sides, both parties. And religious people got hold of this idea of equal time and thought, well, okay, this applies to us too, right? So, in 1973, Tennessee passes a law mandating that evolution be treated as only a theory. You'll hear this phrase again. Creationism should be given equal time, and somehow creationism didn't need a disclaimer. Wow. Daniel versus Waters, this is struck down. You begin to see a pattern. The anti-religious interpretation of the establishment clause is growing, and religious people are sort of retreating to higher and higher ground. Around this time, creation science pops up. Very strange idea. Thought is, somehow the creation story is science. Science backed up by a few doubts about the theory of evolution and a couple of fossils, one of which turned out to be fake. But, one very interesting thing, awfully hard to find out about because there's no proper record. It got settled in a quiet way. Seagrave, where the plaintiffs are, look, my son goes to public high school. They teach him only evolution. They don't say a word about creation science. This violates his free exercise. Whoa, 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 whoa. She lost. She lost, but that case still has consequences that you can see in California to this day. She lost, but she lost. Like some sort of disclaimer in the state science statute. We're not telling you to believe all this. We're just telling you that you must understand it and pass the exam. And this horrendous stuff is still there in the California, the head of the California science standards. You know, all the states have science standards. California's, but for this, are among the best in the country. They're really good. I know some of the people who wrote them, and they are excellent. But this thing at the beginning is completely incompatible with what's going on in the rest of it. And it's still there to this day. It was still there 2 years ago, which was the last time. Around the same time, we get laws mandating balanced treatment of evolution and creation science in Louisiana and Arkansas. You notice a geographical pattern, I guess. The Arkansas law was struck down in McLean versus Arkansas. Louisiana law by the U.S. Supreme Court in Edwards. We'll talk a little bit about McLean. Because in this case, Judge Overton got himself involved in trying to say what amounts to real science. You can see, can't you, he's kind of cornered. He has to rule whether it's okay to give balanced equal time to creation science in a science class. So the question appears to be, is it science or is it something else? Judges have no clue about this. Not a clue. So what the hell are they going to do? Well, luckily the plaintiffs in this case brought in Michael Root, who gave him a criterion derived from Karl Popper. I don't know. I wouldn't say Michael Root perjured himself. I think that would be too strong. But I think he was treading on very, very thin ice. Because the same year that he told the court in McLean, what makes a theory scientific is that it's falsifiable. The theory of evolution is falsifiable and creation science is not. He knew very well that Karl Popper, whose criterion this was, couldn't make up his mind whether the theory of evolution really was science or really wasn't science. So at the very least, I would say, Roos tailored his testimony with extreme care so as not to say anything flatly false, but it was deeply misleading. Second, philosophical intervention. Umpty candidates have been proposed. Popper's falsifiability criterion is by far the most famous. There is no generally agreed criterion for what constitutes science. And in any case, in my opinion, this is a wild goose chase. I think rather than sneering at pseudoscience, it's a lot better to say what's wrong with it in the particular. What's wrong with creation science in the particular? Well, it runs contrary to an enormous body of evidence supporting evolution. And it rests its entire case on supposed difficulties with evolutionary theory, many of which are not real difficulties at all. Last gasp for balanced treatment was Freyer versus Tangipahoa Board of Education. Wonderful name. The disclaimer statement said evolution was presented to inform students of the scientific concept, not to dissuade them from the biblical account. Struck down under Lemon. It's not over. It's not over. While Freiler was winding its way from the trial court years ago, new idea was catching on. Intelligent design theory. This had already made its way into, what shall I call this? A biology text, that's what I'll call it. A purported biology textbook of pandas and people in the edition that was produced 2 years after Edwards. This is important. Very important. You know this book? God, it's awful. It's really terrible. What's most terrible about it? Well, I actually feel awfully guilty. I asked our law school to buy a copy because I was teaching these cases to my students and I wanted them to be able to see what the fuss was about. But I still feel bad about wasting the law school's money on such garbage. The worst thing about it is that if you're a naive 12-year-old, it sort of looks like a science textbook. You have to know something to know that it's not serious. The easiest way to see that it's not serious is to look at the bibliography, which is full of religious material. Another way is to consider the obsession with the supposed lack of transitional fossils, such as transitional fossils between the fish and the reptiles. Now you know why I showed you that good-looking fish. Moreover, we now know, thanks to a philosophy professor from Louisiana, Barbara Forrest, that the new edition of Pragmatism, that's to say the post-Edwards edition, the pre-Edwards edition, which was all about creation and the creator. And then there was a post-Edwards edition where nothing was changed, except wherever the word creation appeared in the first edition, the word intelligent design appeared in the second. And wherever the word creator appeared in the first edition, the word designer appeared in the second edition, except for one place. I don't know how she had the patience to read through all these drafts, but she read dozens of drafts of Pragmatism, looking to see what changes were made. And she found one place where they hadn't finished replacing it. So they'd replaced creationists by C-design proponentists. They've got half the creationists left. This was a creationist textbook dressed up by intelligent design theory after Edwards, because after Edwards, creation science wasn't going to cut it. Intelligent design theory was given a more scientific gloss by a biochemist called Michael Dayhead, who's at Lehigh University. He's a perfectly well-qualified biochemist, I might say. There's nothing wrong with his qualifications as a biochemist. He's also a Catholic, and he was sort of officially disowned by his department after he got involved with his intelligent design business. The rest of his department put something up on his website which says, he's entitled to his opinion, but we think he's nuts. He wrote a book called Darwin's Black Box in 1996. You know, academic biological monographs don't usually sell a lot of copies. This was a bestseller. Boom! Sold millions of copies. Made the publishers very happy, and a lot of people very unhappy. What's the idea? The key idea, the central idea is that there are some biological mechanisms which are what they call irreducibly complex. This is an expression he introduced. What he meant by it was they're composed of many different components, right? None of which would have any function alone. They all have to be together the way the platform, the spring, the bar, the catch are in a mousetrap to have any function. But if they have no function separately, they couldn't have evolved. That was the argument. They couldn't have evolved. They must have been designed by some intelligent designer. Leahy never says God, but I think we know who he means. Here is the most famous example of the bacterial flagellum. Some bacteria have little tails which enable them to move around. That's the flagellum. If you look at the way this thing is constituted, it bears a quite striking resemblance to a little rotary motor. It really does bear quite a striking resemblance to a little rotary motor. And the idea was, well, you know, rotary motor wouldn't just evolve because the bits don't have any function by themselves. They all have to be designed to work together. So guess what? I might say some theologians think this is the most vulgar argument that they've ever encountered. The idea that God can't do any better than he lets a lot of stuff evolve and then he realizes the bacteria need a tail. So he has to intervene and build this thing. I kind of agree with them. I think if it were theology, it's really vulgar theology. Bacterial flagellum became the centerpiece of a federal case. First legal test of intelligent design theory, 2005. Not in Louisiana, not in Arkansas, not in Tennessee, not in Oklahoma, in Dover, Pennsylvania. I was really stunned. Dover, Pennsylvania? I don't get it. I went around asking people, I don't understand. What? I didn't know this about Pennsylvania. I hope you won't be offended by what the answer I got. My friend said to me, look, you have to understand. In Pennsylvania, there's Philadelphia, and there's Pittsburgh, and in between it's Alabama. Okay, this is rural Pennsylvania. As happens from time to time, you know, the textbooks that they've been using for a while were worn out and a bit out of date. And the curriculum committee will meet and decide, you know, do we order the next edition of this, or do we order something different? This is perfectly ordinary. Actually, this was how I learned about Roman Britain when I was in school. Because the year before, what would you like to study? And they said, oh, could we do Roman Britain? So for the next 10 years, students had to study Roman Britain because we had these textbooks. And until they wore out, you couldn't study anything else. Well, the teachers, who seemed to be a very sensitive bunch of people, wanted the newest edition of Miller and Levine's book, Biology. Did any of you use this in school? It's quite standard. Probably, I don't know, at least 25% of public high schools used it. Head of the curriculum committee was one Bill Buckingham, retired corrections officer, with a bad back. As we now know, an OxyContin problem, but we didn't know this before. When he had the bad back and had to retire and life was miserable, the only people who were nice to him about it were members of the left-wing Protestant sect, and he became very religious, probably as a result of the injury. And, life was hard, and they were nice to him. Now he looks at this textbook and describes it as laced with Darwinism. I love that, don't you? As if Darwinism was arsenic. Arsenic is the husband's rice. Big fight on the debate. Big fight on the school board. Buckingham wants pandas and people. The teachers want this standard biology textbook. And everybody's shouting at each other at the school board. You can imagine miserable. And in the end, they reached a compromise position. They would order the book the teachers wanted. Okay. But they mandated a disclaimer to be read before 9th grade biology class by a teacher, or if the teachers refused, by a school administrator. Much to their credit, all the biology teachers said, we are not reading this crap, you read it, you wrote it. It's important that parents could withdraw their child from the reading of this statement if they chose. It's important because the parents of one child who was withdrawn from this were among those who sued the company. I'm going to read this to you paragraph by paragraph with ill-tempered observations about it as I go along. It makes me hopping mad. Hopping mad. It's terrible. Okay. The Pennsylvania Academic Standards require students to learn about Darwin's theory of evolution and to take a test of which evolution is part. Well, to take a test of which the theory of evolution is part, but that's pedantic. Not Darwin's theory of evolution, it's the modern theory of evolution that they're going to be learning about. But never mind, put that. Look at the suggestion. We're teaching this because the state obliges us to. Not because we think it's true, but the state says we have to. It gets worse. So enjoy this paragraph, it gets worse. Because Darwin's theory is a theory, you see theory is grown capital letters, it continues to be tested as new evidence comes in. Okay. The theory is not a fact. Well, no. Gaps in the theory exist for which there is no evidence. What? No, I think they mean there are gaps in the evidence for this theory. There are elements of this theory for which we have no direct evidence. A theory is defined as a well-tested explanation that unifies a broad range of observations. So we've got sneering at it because it's a theory in the first line, and then this definition of what a theory is, which makes a theory sound like a very respectable thing. Same paragraph. These people should flunk the logic exam to get the biology. Intelligent design is an explanation of the origin of life that differs from Darwin's view. True. The reference book of Pandas and People is available to students who might be interested in gaining an understanding of what intelligent design actually involves. Wonderful. Darwin didn't have a theory about the origin of life. Darwin's view about the origin of life was, this is a very hard question. Maybe someday we'll get a grip on it, but at the moment I could only speculate in the wildest way. The reference book of Pandas and People was indeed available. Some kind person had donated 80 copies to the school library. It would be of absolutely no use to any student interested in gaining an understanding of what intelligent design involves, because it tells you nothing about that except, well, an intelligent designer did it. That's not an explanation of anything. Sorry, again, I told you it got worse. With respect to any theory, students are encouraged to keep an open mind. This gave rise to a lot of parody disclaimer statements from physicists about keeping an open mind about gravity. The school leaves the discussion of origins of life to individual students and their parents. Darwin couldn't solve it, biology can't solve it to this day, but you and your mum and dad can sort it out around the kitchen table. As a standards-driven district, class instruction focuses on preparing students to achieve proficiency on standards-based assessments. That's the same dishonest suggestion as in the beginning, and moreover, it's grossly illiterate. I spend half my life trying to stop students writing sentences structured like that. Class instruction is a standards-driven district? What the hell? Sorry. If I may say so, it's dishonest because of this suggestion we only teach this because the state requires it. It's incoherent. It's got two incompatible ideas about what a theory is, side by side. It's ignorant. It thinks Darwin's theory was about the origin of life when it isn't, and it thinks apparently that we now know what the answer is to that question, which we don't. And it's illiterate. Philosophical intervention number 3, this is the third. Yep, the theory of evolution is a theory. And yes, it's possible it could turn out to be a mistake. I would be quite surprised, but it's possible. I couldn't say absolutely. No way, never. But if the theory of evolution is true, evolution is a fact. You see, they've got this false contrast between theory and fact. As if a theory was just somebody's opinion, and a fact was something solid. It's got the relation between the two all wrong. Modern evolutionary theory, which is not Darwin's theory. Darwin, I'm sure, would understand it if we explained to him. But it's not his theory. It's vastly more sophisticated. It's enormously well warranted by a vast mesh of evidence. If you don't know what that evidence looks like, I recommend University of California, Berkeley Biology Department has a website. On the website there is a link to theory of evolution. And under that there's another link to lines of evidence for evolution. And that will take you to 8, 9, 10 different kinds of evidence, all very tightly interlocking. It's remarkable. Intelligent design theory, which says exactly nothing at all about how the designer made bacteria for junk. Isn't by my lights really a theory at all, it's just a slogan. Well, 2005, Tammy Kitzmiller and others sued. Tammy Kitzmiller was the mother of girl in 9th grade biology when the school was first grade. She removed her from the reading of this statement. And ever after, all the other kids in her class teased her. They called her Monkey Girl. Monkey Girl. You think your great grandfather was a monkey? Monkey Girl, Monkey Girl. That was why Tammy Kitchener had standing to sue, because her child had been harmed like this. She sued with the help of the American Civil Liberties Union, not surprising. The Americans United for the Separation of Church and State, I really like that one. The National Center for Science Education, which did all the digging into the Camden Cathedral, and a very expensive Philadelphia law firm, Pepper Hamilton, which supplied two top-notch attorneys to argue the case. Top-notch attorneys, one of whom had been involved in the 3 Mile Island environmental case and was really good at handling scientific testimony. Very important. The two guys from Pepper Hamilton were later described in Philadelphia magazine as Darwin's angels. I think when they first heard who the judge was, they must have been kind of, eek. John E. Jones III, a Lutheran, a Republican, appointed to the federal bench by George W. Bush. The year before, he was head of the Pennsylvania Liquor Commission and was famous mainly for having forbidden an advertisement for beer in which a frog was making an obscene gesture. So they probably thought they were on very shaky ground. They were wrong. Very long trial, lasted, as they said afterwards, 40 days and 40 nights. And Judge Jones said, but not by design. There was a whole raft of expert witnesses, including Kenneth Miller, who was one of the authors of the biology textbook that teaches on the who patiently explained how flagella evolved and what function the components might serve. The pointy bit at the middle of the rotary motor, I won't try to go back to the period, but the pointy bit at the middle of it is exactly, as it turns out, like the little syringe job that the plague bacillus uses to infect its victims. So there's a function for this separately from the bit that moves. And then there are a lot of enormous, I guess you throw money in and it says, we wish you a Merry Christmas. Is this constitutional or not? And the US Supreme Court ruled that it was, on the grounds that the nativity scene was surrounded by so much kit that it was effectively washed out, religious significance was washed out. This is now known in the legal trade as the plastic reindeer rule. You can get away with a religious display in a public place if it's surrounded by enough plastic reindeer. In that case, Justice O'Connor came up with what sounded like a really nice idea, and the Supreme Court bought it, used it in subsequent cases. The idea was, look, we are a nation of radical religious diversity. There are people with every conceivable religion. There are also now many atheists, some of them quite aggressively so. And we don't want anybody to feel that they're not fully a citizen because of the religious views that they have or the religious views that they don't have. So we should be using this establishment clause to ensure that the government doesn't endorse religion over non-religion or one religion over another. In order to argue this, Judge Jones had to make some assumptions, and I think they're not trivial assumptions. Anybody who knew what went on at the school board in Dothan, at the curriculum, knew full well and without a doubt the agenda behind this was creationism. But someone who didn't know that couldn't tell from the statement itself. Do you understand? Jones assumed that the reasonable observer, whom Justice O'Connor had told him to think about, would know about that creationist agenda. And of course, what the reasonable observer would conclude depends on what you assume he knows. When the trial was over, Judge Jones was named one of 200 most influential people of the year. He also received death threats. He and his family had police protection. So he got all sorts of nasty stuff. I watched an interview afterwards, and he said, you know, in one way, it seems like my birthday. You know, my first year on the federal bench, and I get a case like this. Wow, you know, this is a case of a lifetime. That's right. And you know, what I rule is enormously significant to what happens to the establishment of all such. Okay. I never dreamt people would be threatening to bomb my house if they didn't like the ruling. Bill Buckingham was not impressed. He was heard grumbling in an interview afterwards that Judge Jones must have gone to clown school, not to law school. Not fair, of course, but not incomprehensible. It turns out that Buckingham had done some reading on the establishment book, and he found a book which is, in a sense, it's a perfectly respectable book, published, ironically enough, by something called the Wall Builder Press. And this book considers all the cases under the Establishment Clause up until 1952, but not beyond. And everything that Buckingham found in those cases would have supported his view of the matter. It's just that the book he was reading was a work of history which didn't purport to tell you what happened since Edison. But you see why, I'm sure by now you understand my longer title. It's still a bombed under the carpet. The same year as this case, there was a Pew survey. 42% of the people polled agreed living things have existed in their present form since the beginning of time. 42%. Hey, God. There was a conference of teachers, I think in Atlanta in 2008, and the biology teachers were reporting that when we say to our students, okay, well next week we start work on the theory of evolution, some of them burst into tears, and some of them start shouting, no, no, we're not going to listen. So the bulge under the carpet hasn't gone away, and I don't think it's going away anytime soon. I don't think school boards will be anxious to do what the Dover guys did. I don't think they're that in a hurry. Why not? Because Judge Jones awarded the plaintiff's costs against the defendant. So the school board had to pay more than $1 million to pay the other side to sue them. And that's a really serious disincentive to doing this again. No other school board would dare risk running up such a bill. Well, when we're speaking of $1 million, it cost a bit more than $1 million, but that's roughly it. When I taught a class on this in the law school, at that time I had you couldn't give minus grades. I had no idea why. But if you were giving a student a grade, you had to be an A or a B plus, or a B or a C plus. There were no minus grades. And I used to have a really hard time with this. I could spend a week deciding whether it was A or B plus. And I remember reading one student's paper on the Kitzmiller case. And it was quite good. Okay, definitely at least a B plus. And I'm thinking as I get nearer to the end, oh God, this is another week of not sleeping, trying to figure out whether I should give him an A or a B plus. Until I got to the last paragraph. The last paragraph opened, okay, I think the judge made constitutionally the right call. Yeah. But it's a serious question, the student went on. Was it worth it? Was it worth it? Look, it cost more than $1 million. took a lot of judges and attorneys time. It nearly destroyed the town of Dover because people weren't speaking to their neighbours when they were on different sides of this. Well, he said, I think it was worth it. You don't understand the next line until I tell you the reason. One of the stupidest people on the school board was a woman called Heather Geesey. Really? As thick as two planks. No. The attorneys would ask her in court a question to which the answer was either yes or no. And she would mumble for 15 minutes until the judge intervened and said, excuse me, madam, is that yes or is it no? Well, my student's last line was, yes, I think it was worth it, because there are whole flocks of Heather Geeseys out there. I gave him the A. Anyone who can make a joke that good can get the jury on his side and will be a very good attorney. Oh, so what? I told you, I've given you a history lesson. So what? What do I think? Well, first of all, of course I don't want science classes compromised by the introduction of religious ideas. What I want taught in science classes is the best science available. Of course, I want the students to know that science is an ongoing process, that it's fallible, that sometimes things that we thought were true turn out not. But I don't want them told this specifically about evolutionary biology and not about the rest, because it's true. All of it. Hence my advice to my law school students. You know, I guess it was worth it, the $1 million and the disruption and all that. But yeah, a lot better if you guys would go serve on the school board. If you were on the school board, this would never happen in the first place, and that would be the point. However, and if there are any evangelical atheists here, this is the side you're going to like the least. I think it's important that we all remember, even if we have no religious beliefs, as I don't, what the religious bodies are for, and how remarkably well they've succeeded so far. I'm sort of bilingual by now in American and British English, but my American accent is still terrible, so I guess you guessed where I come from. This was something I really didn't begin to understand until I lived in this country. First week in the United States, I'm making a remarkable discovery. The supermarket is open on Sunday. Yay! Right? Never been the case in my entire life before. It makes life very, very convenient to be able to get shop on Sunday. So Sunday morning, I hop in the car and drive to the nearest supermarket, only to find outside the Granada Presbyterian Church a traffic jam. I'd never seen a traffic jam outside a church in my entire life. Never. In England, there is an established church. The Queen is the head of the Church of England, and religion is effectively dead. That's not true yet. Religion is not dead. Religion is alive and well and flourishing and enormously important to an enormous number of people. And yet, in the whole history of this country, you have never had a religious war. Not like Europe. You've never had real serious religious persecution. I know there are a few nuts bombing abortion cases, but relatively speaking, this is nothing compared to the European history that we want to trust. For that matter, I looked at the newspaper before I left this morning, and prominently featured in the Wall Street Journal was this appalling story of a young woman in India who had announced that she was planning to marry a man who was Muslim. And the village elders had sentenced her to be gang raped by 13 guys on jail. That's just horrific, isn't it? It's as horrific as the burning and the Inquisition and all those terrible things that we know about. So, I think it's important not to forget that people's religious ideas, even though they seem completely weird or utterly nutty to me or to you, matter to them. And because it matters to them, it matters to all of us. Both that we allow freedom of belief and that we avoid religious strife. And I now think that the founders of this country were really very wise when they set up those religious bodies, because they've succeeded in doing this to an extraordinary degree, in a way that I think couldn't have been done without them. Thank you.
At this time,
I'm going to sit on the edge of this.
Okay.
Okay.
Does anybody have any questions right now?
Thank you. My name is Matthew. I'm a student here at Troy. May I ask more than one question, please? Just, may I ask more than one question?
Well, I don't know. It depends how long they are. How many other people are going to kill you?
I'll just ask two. Okay. You say, okay, my first question is, you say that pseudoscience should, in your presentation, you say pseudoscience should not be made fun of, but I'm sorry, I can't read my own handwriting. I have to Okay.
Don't jeer at it, I say.
No. Insulted, I think, is what I put. I think that's what your words were, insulted. You say that pseudoscience should not be insulted, but pointed out what's wrong with them, and I agree with that. So my question is, why then do you insult people that do not agree with you, your sarcastic tones and calling people idiots and ignorant? And if you want to answer that one, you can, or I can just go right to the second one. And my second question is, what would you say to someone that sees, I'm sorry, I'm going to premise it with this. We live in a world that everything has a beginning and an end, a cause and effect. What would you say to someone that sees an eternal creator as the only logical answer to creation, i.e. the cause that caused the cause that caused the cause, and so on, is not logical? I have a couple more. But
okay, the easy answer, the straightforward answer to your first question is, yeah, I know. That statement makes me...
I understand you were being funny.
No, that statement makes me very cross. It is... The sheer illiteracy of it bothers me, for one thing. But I said specifically, this is what's wrong with it. This is dishonest. There is a suggestion we only teach this because the state requires us to. No, that's not why the biology teachers teach evolution. They teach it because it's a very well-warranted scientific theory, and we want our students to know about it. It's incoherent. It has two incompatible definitions of theory, side by side in the same paragraph. It's ignorant. It suggests that Darwin's theory was a theory of the origin of life. It is not. Darwin specifically raises this topic and specifically says, I don't know. This is beyond people's two parts.
If I may, you did say that Darwin said that you said that the evolution does not jive with religion because it suggests that man was not created in
special
God's image.
Yes, special. Yes.
So my question then would be, if that is enforcing a religion, i.e. atheism, which a definition of religion.
Okay.
Well,
okay. I want to say something to that.
Yes.
I do want to say something to that. I think you can see. You would see if you were to look. There's a very interesting, though I think rather slanted documentary on the Dover case called Judgment Day. It was made by Nova. So it's very clearly on the side of the plaintiffs. It's very unsympathetic to Bill Buckingham, for example. But one of the things that I think you can learn from is that some people do really feel extremely strongly that teaching the theory of evolution in biology classes and not mentioning any, they say alternative, but I think I'm going to wave my fingers around because they're in a different class. They feel that this is imposing a non-religious belief. And that thought doesn't seem to me to be completely stupid. That's why I think these clauses are so important. It's also why I think that as they're passed in 1791, a long time ago, the world was very different. That was part of my story. The world was very different now. They have been interpreted and interpreted and interpreted over hundreds of years by courts. As they've been interpreted, the scope of each of them has got broader. And the danger of them coming into conflict with each other is now much closer than it used to be. There are times when I say to myself, they've interpreted the hell out of these clauses, and if they go much further, we'll discover that you can't satisfy both of them.
But the Constitution doesn't say separation.
No, it doesn't. No.
And Thomas Jefferson actually held church services in the Capitol building.
And, okay. And there are still, look, if you look at that documentary, which will show you, I'm afraid they're acting because they couldn't have cameras in court, but they'll show you scenes from the courtroom, including actual Judge Jones in the actual court. And you can't fail to notice the irony, because behind him in federal court is an enormous seal on which it says, "In God we trust." So what we have is a setup with, from an initially Christian nation, in some quite profound sense, things which still remain, like the opening prayers of the Nebraska legislature. Right? There's a case before the Supreme Court at the moment about a prayer before the town meetings in the city of Greece. Right? And there are precedents for allowing it. So I'm not suggesting for a moment that it's easy to sustain defensible interpretations of these two clauses and keep them compatible with each other. It's hard. That's why I think it's so remarkable that thus far the courts have succeeded. But we haven't had wars. And as for the second question about the cause of the clause, I have to say, I keep trying to read books of cosmology. Hawking's like to read one, and I try to read it. I even wonder to read one, and I think I've got it for 10 minutes. It's too hard. I sort of get the idea about the accretion of matter. Right? But beyond that, it's highly controversial cosmological theorizing. I have no idea what the truth of this is. I just don't think that a religious explanation really explains it. But that's a whole other story.
Does anybody else have any questions about the lecture tonight? Okay, we are going to have Dr. Haack come and do a book signing right now. So if you want to come and see what we have available, or if you brought any books on your own, thank you again.
Thank you.